Court does call the case of the people versus James Johnson.
On behalf of the people.
Assistant Public Defender Melissa Kleeman on behalf of Mr. Johnson. And sir, can you state your name for the record, please?
Yes, James Johnson.
Thank you. And Your Honor, in regards to the bond violation, I have had a chance to speak with Mr. Johnson. Mr. Johnson denies that he had knowledge of the no contact order, but he does admit that he's had contact with the complaining witness.
What does he mean he is? I guess I don't understand that.
He said to me he was not aware that there was a no contact order when I went to speak with him about it.
Are we talking from the March date?
I suppose so, sir. You're saying that you never knew that there was a no contact order. Is that correct?
Yeah, I mean, if I, you know what I'm saying, if it is a no contact order, I didn't know that I couldn't talk to my child mother. Like I say, yeah, I admit that I've had conversation regarding, you know what I'm saying, my son and stuff like that. You feel me? But yeah, I admit that I did have contact with Mrs. Henderson, or whichever last name y'all might got, Powell. But I do admit that I have had multiple contact with Mrs. Powell or Henderson. You know, like I said, we have a child in common, so we speaking about, you know, his birthday at the end of this week. We've been speaking about that. We've been speaking about a lot.
Mr. Let me.
Excuse me, Your Honor.
Before he goes,
Miss Henderson, hang on 1 second, okay?
Okay.
Before
Miss
he
Henderson
goes
is here and wants to address the court. Thank you.
Before he goes on that and starts trying to say what the calls were about, he needs to be aware that those calls were recorded.
Yes.
Probably, and there's a whole lot more on there than just that.
Yes, for sure. And I'm aware. I mean, yes, Your Honor. Like I said, I've had multiple conversations with her, and I'm not trying to play on your intelligence.
Well, hold it. I don't mean to cut him off, but I guess I do, because those conversations may form the basis of additional charges, and I don't want the defendant saying anything that may jeopardize it, which is the reason I'm trying to stop him from saying what he's saying.
Yes, sir. I understand.
Anything from the people?
Yes, Your Honor. So there has been, I attached the bond form as Exhibit 1, which was, he was made aware at his arraignment from Magistrate Fink as of March 9th, 2022, that he was not supposed to have contact with the victim. As of this morning, the defendant has made 71 calls, including one call at 9:40 a.m. to the victim. I have spoken to Ms. Henderson. The victim advocate has spoken to Ms. Henderson. I did see the emails that she sent to the court on behalf of herself and Mr. Johnson. It is my understanding she does not want to participate moving forward in this case. That being said, some of the calls I have viewed and attached have resulted in witness interference charges that have been charged but not typed or sworn to yet. So Mr. Johnson will have a felony resulting from the calls. So my concern is that just listening to the calls, I did speak to Ms. Henderson. She did tell me she does not want to proceed. She did tell me that she wants Mr. Johnson released for her children and for his other children, that they are starting school, that one has a birthday. I explained that at the time I spoke to her, that was not the only thing holding Mr. Johnson. At that time, he had a different case, which has now since been dismissed. I also let her know that there are other options. I believe she spoke with the victim advocate who made her aware of those as well. It's still my understanding she's no longer wishing to proceed. That being said, in the calls and the nature of the calls, I do have concerns about what Mr. Johnson told Ms. Henderson to do. And even the emails that were sent, Mr. Johnson told her directly to send those emails and where to send them to, including to Judge Conlon's court where he has his felony case. He also instructed her to send an email there. So I do have concerns with Mr. Johnson still speaking to Ms. Henderson, regardless if she wants the no contact order or not, just in relation to this case. Also, in the jail calls, it was spoken about the actual charges of this matter. While Mr. Johnson made no admissions, Ms. Henderson did restate that that event did happen and that this is being treated like a home invasion, whereas it was just him kicking the door in.
No, can I say something?
Excuse me, when do I speak?
But sorry, one second.
When can I speak?
Ms.
with the
Henderson,
judge?
we spoke and Ms. Roddy spoke to you, and this is not the forum for you to speak.
Yeah, that's when you told her that I was a bad guy.
Sorry, sir, hang on one second. Okay. And I do think the complaining witness would like to address the court. She has reached out to me as well, expressing that she doesn't wish for this court case to go forward and that she would like the no contact order lifted.
Can I speak as well?
The problem is going to be this, and that is she can address the court, but you know, the reality is if the calls that are made meted out, they're going to be able to use their statements and proceed by forfeiture. I mean, that's the problem with everybody saying everything. So I mean, if she wants to address the court, she can, but it's not going to do any good. It's not. I mean,
Your Honor, honestly, she been told Miss Kirby Caitlin before the charges even was brought about. She, you know what I'm saying? She been saying this, and Caitlin told her that.
Hold on, Mr. Johnson. I think, and I'm really going to advise you again. I think you need to be real careful about what you're saying.
Okay.
Because there is a felony charge that my understanding is going to be pending very soon on very serious charges. And as I told you before, when we were dealing with your other cases, you tend, despite what your attorneys are telling you, to launch yourself into some stuff. And even you talking right now, this is the third time I've tried to stop you. You are just digging yourself a huge hole that in reality you may never get out of. And it's not going to be anybody's fault but you and your mouth.
You're right.
That's the best way that I can put it to you.
I understand. You know, I mean, you didn't have multiple. I understand though, and you didn't have multiple conversations, and you have informed me multiple times on several different matters.
To be quiet.
Quiet, yeah.
And let your attorneys do their work, because you just keep trying to interfere, thinking that you're getting ahead, and you are just flying out of the world backwards.
Yeah, I'm really trying to get myself up out of holes.
But you are not doing yourself any favors.
You're right. Well, Melissa, could you, if you would like to speak for me, please?
Yeah. Yes. And I do know Mr. Johnson strongly is asking the court to consider a dismissal. I have explained that the procedure would be to set it for a final settlement conference, and it would be at that date when we would see whether or not the prosecutor could proceed. But he is asking the court to consider a dismissal today. In lieu of that, I'm asking the court to consider lowering his bond. It is, I believe, at $25,000. That is not something that he can afford to post. And I'm asking that in conjunction with the fact that the complaining witness has represented to me that she doesn't want to move forward with the case.
Yeah, but you do understand that there's a method by which the people would be able to proceed in this case. And that's why I was trying to get the defendant to just be quiet, because he's added fuel to the fire in that regard. So, I mean, it wouldn't be your standard case of setting it. She comes in, says, I don't want to proceed, particularly if the court makes a finding that the basis upon which he's not proceeding is because of statements that the defendant made. I mean, So there's, all right. When, are the felony charges already done? Or
Yes.
Mr. Johnson?
The
please.
current ones that he has,
Yes,
so he has the one case was dismissed, and then he just had a probable cause conference last week on the felony R&Os. I can see what date those were.
Yeah, I'm a PR for them, I believe. Hey, Miss Kleeman.
Yes.
You,
and Ms. Kirby, I guess what I'm wondering is the interference with the witness. Have those charges been filed already?
So they have been charged, but they haven't been signed yet because they haven't been typed yet. So they need to be typed and sworn out.
Okay.
Should I can put a rush on it and have it ask the court officer to try to swear it out today. All
right. Because frankly, that is going to have bearing on this case. I mean, that's going to be the reality of it. So,
Your Honor, not on this matter. I have also a matter in front of you. I believe the case docket is 201-0608-SD. I remember last week we were speaking on that reference. I seen you last week on that matter, and you told me that we can revisit that issue when I see you again on this week. You got my bond set at a $25,000 bond on that as well. I was asking for some type of lowerance of that bond too. I mean, I'm trying to see my son first day of school as well as his birthday party this week. So, I mean, I've asked that you would consider that as well. And that's
Mr. Johnson.
Your Honor, that's operating while intoxicated. It appears the other felony got set for an exam on the 16th in front of Judge Balbo.
Let me just say this. And Mr. Johnson, I told you that hoping to get all of these things done. And
yes.
part of the problem with you is, as I tell you these things, you keep opening your mouth, causing more problems. I don't think you appreciate, even though I keep saying it to you, what a mess you have now created for yourself. Within less than a week's time, you've changed the complexion of all of this by opening your mouth. So, Ms. Kleeman, did you want this set for final settlement conference and jury selection? I mean, I just have a feeling this is going to head in a whole different direction than it normally would. But I mean, I can set it, but
that's what he wants to do.
So when do I get to address the court?
What do you want to say, ma'am?
I want to say that I don't want to move forward with these charges, and the man needs to be home. Like, we need him out of there. You know, like, my son's first day of school is coming up. Like, it's his first day of school, period, overall. I don't want him to be in jail at all. He needs to be home. He has other kids. He needs to be home for it. And he's innocent. He didn't do it. And that lady I didn't have a conversation with that lady. That lady argues with me. I mean, from the time that I called her, the very moment that I said I didn't want to move forward, She literally argued with me the whole time, and she rudely interrupted the call, just hung up on me in my face. I asked to speak with multiple supervisors, never got a call back about the situation. Like, it didn't even have to go this far. Like, she want to do this. Why? I don't know. It's like it's like it's not this serious. And he never intimidated me or anything, like nothing. And I was never aware of the no contact order either.
Have you finished?
Yes.
So final settlement conference in this matter, might as well do the 17th and the 19th. Final settlement conference will be August 17th, 2022 at 1:30. Jury selection, if necessary, August 19th, 2022 at 8:30. I was sincerely hoping that at some point I could maybe reduce your bond in these cases, but given what I've seen, Mr. Johnson, you just keep messing this up. So I'm going to continue his bond. It's for a few more days because the other on his prelim that he's got on the 16th. What's his bond on that one?
His bond is still denied as to the probation violation. He has two bench
Mr.
warrants.
Johnson, please. Go ahead, Ms. Kirby. What were you
Yes.
saying?
He has two bonds on this court's cases, the OWI and the MDOP. And then I don't see, I believe they are PR bonds on the R&O.
And the probation violation, my understanding is it was tracking the armed robbery case that got dismissed. So our understanding is the probation violation itself should be dismissed this afternoon as well.
And then there's, I'm sorry, so on the R&O, there's a $5,000 bond. And on the A and B, there is a $5,000 bond. And then appears a trespass, a disorderly disturbing the peace, and another trespass. He was sentenced for this last week.
You were sentenced on those?
Or he took a plea is what the
Flag, if I recall correctly, yes.
Ms. Kalimi?
Yes.
Well, I'll wait because I still won't be like I'm addressing the court, so I just wait.
Here's what I'm going to do. I can only set these as soon as possible. Ms. Kleeman, I think you can appreciate what I'm indicating, that I'm trying to tell your client, that it becomes very difficult for me to do anything because he keeps opening his mouth and he keeps putting himself, and he didn't have a felony charge and now he's going to have another one. And he's asking me to reduce his bond because he's got, So what I'm going to do, I've set this out 9 days from today's day. On this matter, I'm going to continue his bond. Counsel, as you know, the position of the complaining witness in this case, I think counsel need to get together as to how this matter is going to proceed. If it's going to proceed along the lines of some forfeiture based upon that other felony charge, or that felony charge is going to proceed, then I can, by written motion, take another look at his bond in this matter. But I mean, he just keeps making it difficult. And Not a whole lot I can do. So I'll just continue it at this point, but figure that one out. Let him get arraigned on the other matter. And then we can see where this one as well as the other one play into it. That's the best I can do. And
Okay.
and Ms. Kleeman, you can have a very frank conversation with him as to how he's getting himself into this mess.
So what is the felony matter that you saying I got coming pending? I think I might hire outside help for that. Because I got a malicious prosecution lawsuit already being pursued.
Okay, it should be sworn in today, is what the prosecutor said. So it should be coming. Hopefully you'll get the information by the end of the week, I would think.
And I'd like to have that one, I guess the other thing I'd say, so we can try to get these all together. I'd like to have that one filed if it can be administratively done prior to his final settlement conference, or certainly prior to the jury selection.
I only had the two misdemeanors for $25,000 bonds that's holding me in here right now.
Well, that's not my understanding of what they're saying.
Yeah, honestly, that's why I wanted to address you. I have PR bonds on the cases that you gave me for the felony matters next week. My probation violation right now, I can get the officer to come in here and tell you I'm only being held in here on 3 charges. Probation violation for the
Ms. Kleeman, put together everything that he says, because the other matter, he's just not getting this. It was tracking that case. It should be dismissed, but right now it's not dismissed.
Right.
No matter how much he's saying it to me, it's not. So, I mean,
yeah,
I'm done
today. I'm 30.
Done.
Hey, Ms. Kleeman, I'm gonna give you the contact. I'm gonna give you my Wayne County lawyer as well, so that you can give him the charges that's coming about. Because I've told you, I got the malicious lawsuit coming in. I'm filing for malicious prosecution. So I would like
they can
Your Honor,
talk to each other some other time. Yes.
before Mr. Johnson gets off the call, I would just ask to reiterate the no contact order.
All right. I think it's rather clear that there is a no contact order at this point in time. Mr. Johnson? You can just have a seat. And I'm just going to tell you this. There is a no contact provision at this point. I'm going to strongly suggest to you, sir, that certainly within the time of now, well, it will continue, but certainly between now and the final settlement conference, that you abide by that letter.
So that means, can I call their number to talk to my son at least? If I'm not contacting her, I can contact my son, correct?
Sir, I've told you what the no contact provision is. I'm imploring you to do something. You don't tend to follow what I'm trying to tell you, but I'm just going to say it again to you, and you're going to do what you want to do.
No, I'm asking for the number, because that's the only number that I have to contact my son. So I'm asking, can I contact the number for my son?
Not now, sir. It would be safest to not do that right now for the next 9 days.
Okay. So,
Thank you.
I mean, hey, tell him happy birthday.
Thank you. Here's that.
Number 21, and case on the supplemental, People versus James Johnson, 251 FH 2203 FH.
Nimesh Kanatra, First Assistant Prosecuting Attorney for the People.
Sandra White on behalf of James Johnson.
Sam Bernstein for James Johnson on 20051 FH.
And
Mr. Johnson, can you hear us?
Yes, sir.
Okay. Today's the date and time on the
2051 FH case for violation of probation. And so there are 6 outstanding violations alleged. And then additionally in the 220003 FH, this is a pretrial. So I guess, are we intending to resolve one and pre-try the other? Or are we going to keep them tracking together? Counsel, what do you think?
Your Honor,
I believe we're going to keep them tracking together, Your Honor.
Mr. Bernstein, is that accurate?
That is accurate, Your Honor.
All right. So let's start then with the pretrial, because that's likely to be the driving calendar effect here. So Ms. White, have you had an opportunity to speak with the prosecutor? What are we gonna do today?
No, Your Honor, I was just made aware Friday this was going to be added to the docket. So I haven't had a chance to talk with the prosecutor or Mr. Johnson about how to proceed. I know we are waiting on cases to come together, so possibly having a global resolution. And Mr. Johnson does have a preliminary exam scheduled for the 16th.
Okay. Well, how far out should we adjourn this?
Your Honor, if I could let the court and counsel know, there is that aforementioned Ms. White prelim exam on August 16th. I believe it's 3 counts of felony RNO. I was made aware by my colleague today that she is authorizing a witness interference charge. That's a felony charge that might be sworn to today. And if that's the case, there'll be a new felony pending at the PCC stage in the next week or two with Judge Simpson.
So if we were to adjourn this to that September 7th date, would that be time for us to see what's happening in the case?
Definitely to take stock of things.
All right. So just so that you're all hearing this, we're going to adjourn both matters to September 7th at 1:30 p.m. Note that that's a Wednesday. That is not my messing the date up. My dockets are going to move to Wednesdays in September going forward. So I'm adjourning both of these matters. And obviously, if there's anything else that catches up, we will adjourn that to September 7th as well.
Your Honor, I believe Mr. Johnson would like me to address bond.
Okay, go ahead.
I believe part of his decision to keep him in custody, and I could be incorrect because I wasn't at all the proceedings, was to do with an armed robbery charge that has been dismissed. And Mr. Johnson is, as I believe Your Honor knows, the sole provider now for his daughter, the sole parent. So Mr. Johnson would like to, I don't know if he turned himself in on this charge. I believe this time, I believe he did not. He's shaking his head no. I know he was making arrangements. He was talking to me to turn himself in. He had to make arrangements with his daughter. So, and Mr. Johnson is aware of his charges and has been trying to take care of them. So I'm asking that the court do grant him a personal recognizance bond or a bond with a tether.
Is there anything you need to add to that, Mr. Bernstein, before I invite Mr. Ganatra or probation to respond?
No, Your Honor, Ms. White articulated that very well. Thank you.
Any thoughts, Mr. Ganatra?
I oppose the reduction, Your Honor. I think that unfortunately the defendant has had a number of cases in the last year or so. He's on probation to you for possession under 25, controlled substance case, and a felon in possession of a firearm. The guidelines on that are 9 to 23. That's violation of probation. The drug case that he has pending here today for a pretrial, 3 counts of delivery, that's 10 to 23 guidelines. I've just mentioned the fact that there's a new warrant request being authorized and sworn to on a witness interference, which is associated with a case that was pending at PCC exam with Judge Simpson, and it got remanded to district court, but that case is still pending, which is a destruction of property. I believe Judge Simpson has a 25,000 cash surety bond on that case, that being a misdemeanor. But given the defendant's entanglements with the criminal justice system in the last year, I don't think it's a good bet to release him at this time. I think he presents a threat to himself and others, and I think that he should remain at the current bond as it's set.
Okay. I do appreciate the argument. I am not only concerned with the sort of the alleged new cases, but I'm also concerned with the prior history of bench warrants in this case. So I'm going to remand the defendant pending that pretrial and the violation of probation hearing on September 7th, 2022.
Thank you, Your Honor.